Mas já vamos caminhar? Não. Oi, som. Oi. Testando.
Isso é complicado até de ligar.
Boa noite a todos. Vamos dar início aqui à celebração dos 20 anos da Quinta Jurídica. Queria inicialmente registrar o meu contentamento e a minha felicidade em ver mais uma vez essa casa lotada. É um dia muito especial para nós que compomos a Quinta Jurídica. Terei umas breves palavras a dizer antes de passar para o nosso ilustre convidado do dia de hoje. Queria inicialmente saudar todos e dizer que é com imensa alegria e orgulho que estamos aqui reunidos para celebrar os 20 anos da Quinta Jurídica. Tudo iniciou há 20 anos, de um ano de 2004. Coincidentemente, foi o ano que eu ingressei na faculdade. Então, a história da Quinta Jurídica está muito entrelaçada à minha vida de estudante, que foi quando eu iniciei há algum tempo, 20 anos. E ao longo dessas 2 décadas, a Quinta Jurídica ela vem se consolidando, ano após ano, como um espaço muito positivo de diálogo, de troca de ideias e de aprendizado contínuo. Neste período de 20 anos, tivemos muitas mudanças, mas o mais importante é que a Quinta Jurídica nunca deixou de existir. Nós nunca tivemos uma pausa da Quinta Jurídica, nem no período da pandemia, quando houve a necessidade de nos reinventar. E a Quinta Jurídica ela sempre esteve na vanguarda dessas transformações, se adaptando ao formato híbrido virtual, para que a gente pudesse manter esse projeto, que é o projeto mais longevo da Quinta Região, e que muito orgulha a nossa instituição. Eu teria muitos agradecimentos a fazer, vou fazer alguns registros, peço já minhas escusas Caso eu tenha algum esquecimento, mas eu queria agradecer, demonstrar minha profunda gratidão a todos vocês que nos acompanham durante 2 décadas, aos magistrados, aos servidores, aos nossos palestrantes. A Quinta Jurídica é um trabalho voluntário de todos os envolvidos. Os palestrantes, eles prestam um importante contributo, eles são fundamentais para o nosso evento acontecer. Eles não recebem nenhuma remuneração por isso. O objetivo é difundir conhecimento jurídico e trazer para vocês um evento de qualidade. Gostaria de agradecer aos servidores que estão sempre nos bastidores, nos auxiliando. Aqui eu vou fazer em nome de Nevonice, que é minha fiel escudeira, e que está sempre nos auxiliando. Nevonice é a queridinha dos alunos da curadoria. Tem aqui o fã-clube Nevonice. Nevonice socorre, Nevonice resolve, Nevonice é resolutiva. Queria agradecer aos nossos parceiros. Queria também reforçar, né, que a Quinta Jurídica, além desse viés jurídico, ele sempre teve um viés assistencial. Como disse, assim, não tem inscrição, né, não tem pagamento, a gente sempre pediu doações para instituições que a gente mensalmente elegia para receber essas doações. Então, a Quinta Jurídica, ela viabilizou a doação de muitos alimentos e foi muito importante na história dessas instituições e desses projetos sociais. Também queria fazer esse registro, queria registrar os estudantes que estão aqui, nos acompanhando, cheio de força, de ânimo, de gás, e dizer que vocês são um dos nossos motores, o que nos move a trazer esse evento de qualidade. E é isso, estamos aqui há 20 anos. O slogan que foi escolhido para a Quinta Jurídica foi Quinta Jurídica Retribui. E eu acho que é muito pertinente a frase, porque estamos aqui para retribuir o que nós recebemos de vocês durante esses 20 anos. E nada melhor do que fazer esse evento de celebração. Nós estamos assim com um mês todo de comemoração. Nós teremos essa edição do dia de hoje com o nosso ilustre professor. Teremos a Quinta Jurídica Especial também na próxima quinta-feira. Então, todos que estão aqui estão convidados novamente a voltar. Nós teremos a Quinta Jurídica dos nossos terceirizados, que vamos tratar do planejamento previdenciário. Teremos Quinta Jurídica nas escolas, alguns magistrados irão nas escolas, Marco Bruno vai a Itaipu, alguns colegas vão a Sul, a Pau dos Ferros, já iniciamos isso, eu vou próxima semana no Ateneu. Então, estamos com várias vertentes no intuito de marcar a celebração dessas 2 décadas de Quinta Jurídica. Quero desejar e torcer que os 20 anos, que os próximos 20, 30 e quantas décadas tivermos, que elas sejam tão produtivas e significativas quanto essas 2 décadas foram. Então é isso, muito obrigada a todos, que tenhamos uma excelente edição comemorativa. Vou passar a palavra aqui ao diretor da Escola da Magistratura, doutor Marco Bruno, que foi fundamental para que essa edição comemorativa saísse da forma como que saiu, ele que se esmerou muito, se dedicou muito. Desde o início do ano, a gente começou a planejar isso, e assim, com muito carinho, a gente entrega essa programação para vocês. Também queria fazer o registro da direção do foro, que viabiliza a realização desses eventos, e a todos os presentes, meu muito obrigada, uma boa noite, e seja bem-vindo, professor.
Obrigado, Monique. Eu queria inicialmente dizer umas palavras. Já que você me deu a palavra, eu vou aproveitar, porque tem algo que muito me emociona no dia de hoje, porque Monique é a coordenadora da Quinta Jurídica, mas eu fui o coordenador da primeira Quinta Jurídica 20 anos atrás. Não sei se isso me favorece, né? Porque tem uma série de repercussões em torno disso, mas o fato é que eu fui o coordenador e é muito feliz de ver alguns rostos, por exemplo, que estavam aqui, a começar pelo então diretor do foro, que era o professor Ivan Lira. Então, peço uma salva de palmas para algumas pessoas que fizeram história aqui. Foi ele que permitiu que esse projeto fosse implementado. A gente sabe que isso tem impacto na direção do foro. Queria fazer um registro da minha querida amiga, a juíza Flávia Dantas, que era parceira do evento no início, através do Instituto Potiguar Direito Público. Peço uma salva de palmas também. Eu queria fazer um registro de gratidão ao ministro Rezec por participar aqui do evento conosco. É uma honra imensa, ministro, tê-lo aqui. Batam forte essa palma, minha gente, para que ele... Muito obrigado. Considerem-se todos cumprimentados. Foi apenas um registro, meu amigo Sidney Guerra, que eu não via há tanto tempo. Uma alegria, amigo, tê-lo aqui também. É, E queria fazer uma. Eu sei que eu não vou poder nominar, mas eu peço muito forte também essa salva de palmas. Eu vou dizer genericamente, infelizmente, Dona Elza, que é a nossa copeira, não está aqui, que estava aqui todas as noites há 20 anos na Quinta Jurídica. Ela está aqui, mas não está aqui agora. Ela não está aqui agora, mas eu queria fazer um registro à Dona Elza, a equipe de som, as pessoas que realmente fazem esse evento acontecer. Monique fez menção ao evento como Quinta Jurídica retribui. De fato, nós estamos retribuindo durante essa semana e a outra o carinho e a alegria que recebemos de vocês. Então, cada um dos juízes aqui escola pública para interagir com alunos, e essa quinta jurídica aos terceirizados é justamente, vai ter uma quinta jurídica, o professor Fábio Bezerra, que ali se encontra, vai dar uma aula de planejamento previdenciário para todo o nosso staff de terceirizados, vigilantes, copeiras, o pessoal da recepção, auxiliar de serviços gerais, como também do nosso projeto de reeducandos. Nós temos aqui um projeto há quase 30 anos. Quanto tempo, Ivan? 30 anos, não é? Tem, não é? 94, exatamente. Há 30 anos a gente tem um projeto de ressocialização de presos. E a Quinta Jurídica também haverá. O professor Fábio vai também palestrar para os presos, né, no caso que estão se ressocializando aqui conosco, nesse projeto de gratidão ao que eles fizeram por nós, porque são eles que fazem esse evento acontecer. Então, peço uma salva de palmas a cada um deles com o coração pulsante. Nós temos a alegria e o prestígio hoje de recebermos o professor Fausto Pocar. Eu vou dizer a vocês um minutinho. Now I'm going to introduce yourself. I'm going to introduce you to the audience. O professor Fausto Pocar é um dos maiores internacionalistas da história, como também o professor Rezec, um privilégio ter os dois aqui hoje. Ele é doutor em Direito pela Universidade de Milão, vai durar um tempinho aqui, viu, minha gente? É doutor em Direito pela Universidade de Milão em 1961. É livre docente em Direito Internacional, professor de Direito Internacional na Universidade de Milão desde 76. Ele lecionou Direito Europeu, Direito Internacional Privado, Direito do Trabalho Europeu. Ele é professor emérito de Direito Internacional, foi vice-reitor e membro do Conselho Administrativo da Universidade de Milão, fundador e diretor da Escola de Pós-Graduação em Direito e Economia da Comunidade Europeia da Universidade de Milão. Foi decano também da Faculdade de Ciências Políticas e membro do Senado Acadêmico da Universidade. Diretor dos Institutos de Direito Internacional da Universidade de Milão, membro do Comitê de Pesquisa Jurídica do Conselho Universitário Nacional, e segue. Aí ele foi editor-chefe, membro de inúmeros periódicos, ministrou vários cursos na Academia de Direito Internacional da Haia desde 1983, como também em inúmeras universidades. Eu vejo aqui a Universidade Complutense de Madrid, a Universidade Complutense de Madrid, enfim, várias outras, a Universidade de Tessalônica, na Tunísia. Aqui é interessante também, Belo Horizonte, consta no currículo dele, no CEDIM. Profissionalmente, ele é membro da Ordem dos Advogados de Milão desde 63. Ele é habilitado a atuar na Corte de Cassação Italiana, que é o órgão máximo do Judiciário da Justiça Ordinária. É membro do Clube de Árbitros da Câmara de Arbitragem de Milão, representante do Clube Não Citral, busquem aí o que é um Citral. Membro e presidente do Conselho do Comitê Científico da Câmara de Advogados de Milão, e segue árbitro, advogado, etc. Tem um vasto currículo aqui na advocacia. Depois, nas atividades internacionais, ele foi juiz ad hoc na Corte Internacional de Justiça, no caso Bélgica versus Suíça, presidente do Tribunal Penal Internacional para a ex-Iugoslávia, foi também integrante da Corte Internacional, no Tribunal Penal Internacional de Ruanda, e inúmeras outras atividades, incluindo integrante da Comissão de Direito Internacional da Organização das Nações Unidas. Professor, it's an honor for us to have you here, Natal. We were saying that for 20 years, we've been every month promoting this event. It's an event that we really care for the judges here and the whole court. So it's a privilege to have you here tonight. And I invite you to give your lecture. We're gonna hear with attention. Thank you very much.
Okay. Muito obrigado, querido amigo Luis Marco Bruno Miranda, por me dar la palabra. Es para mí un grande placer y un grande honor haber sido convidado a realizar esta conferencia en la Corte Federal en Natal. Meus vivos sentimientos de agradecimiento van a la Corte, a sus miembros que están en la sala, y un agradecimiento especial a juez Marco Bruno Miranda para la organización de esta conferencia. Infelizmente, no puedo preferir mi conferencia en brasileiro y peço disculpas, se usa el inglés. Parece que hay una inteligencia artificial que va a hacer la traducción. Esperemos que sea buena o que mejore mi discurso. My subject for this conference here is on international criminal justice and the domestic courts. And then I put an interrogation mark saying, is this a vertical or horizontal relationship? Can we say there is a structure, a hierarchy between the international domain and the national domain in this matter? Let me start by saying that in the last decades, we have seen a proliferation of international courts and tribunals as a consequence of the increasing role of international law in dealing with the protection of individual persons and interests, and the more recent perception of the need for an international approach to the consideration of global values and public interests. Thus, while traditionally international courts and tribunals, including international arbitral tribunals, had a specific function to settle disputes between states, a function that has remained a priority with many of them, newly established courts and tribunals have been given special competencies which go beyond the function of settling international disputes, but encompass protecting individuals under international law and ensuring respect for global values and public international interests when they come within the normative field of international law. So far, two areas have been especially involved by these developments: human rights law on one hand, and criminal law on the other hand, two fields that are strictly related, since both aim at protecting the human society and its individual members from abuses that may endanger their peaceful common living. As of long established at the domestic level, these two types of courts, they both acquired a recognition internationally rather recently, in the midst of last century, in the aftermath of the Second World War. As to human rights, with the Charter of the United Nations, and that is June 1945. Before, human rights were not a matter in international law, were a matter in domestic law, constitutional law, but not necessarily internationally. And as to criminal law, a couple of months later, with the London Agreement, established the International Military Tribunal, that better known as the Nuremberg Tribunal, to try the Nazi criminals. Now, with respect to human rights, in the second half of last century, several international conventions have been concluded at the universal level within the framework of the United Nations, providing for universal quasi-judicial procedures aimed at guaranteeing an international protection of human rights. They say at the same time, international courts have been established at the regional level to achieve more binding results in this field. In the Americas, you have the American Convention on Human Rights. In Europe, the European Convention on Human Rights. And in Africa, the African Convention of Human and People's Rights. The procedures of these courts and their relationship with domestic courts, including their concurrent jurisdiction and the priority given to national courts as a condition to accede to the international courts under the classic rule of the previous exhaustion of local remedies, has been widely explored. Everybody knows how it works and does not need to be specifically addressed here. I will not deal with that specifically. But with respect to criminal law, the international community has shown an increasing public interest in combating impunity for war crimes, genocide, and crimes against humanity, and the proliferation of courts and tribunals has characterized the implementation of this interest, clearly rooted on the precedent set by the Nuremberg and Tokyo military tribunals, which were established by the Allied powers at the end of World War II. Following these precedents, the United Nations Security Council created two international tribunals, the International Tribunal for the former Yugoslavia in 93, and 1 year later, in 94, the International Tribunal for Rwanda, for the genocide in Rwanda. And they were mandated to prosecute persons responsible for the commission of the same cluster of crimes. So war crimes, genocide, and crimes against humanity. The establishment of these two tribunals ad hoc demonstrated the desirability of an international permanent criminal jurisdiction. And as a consequence, following the conclusion after many years, half a century actually, of the drafting of a code of international crimes by the International Law Commission of the United Nations, the United Nations convened a conference in Rome where the statute, that is called the Rome Statute of the International Criminal Court, was adopted in July 98, and the court started to be operative in 2002. This step, however, should have finished reaching the result of an international, universal, and permanent court, the proliferation of courts, but did not. That proliferation has not been limited, and other criminal courts have been established with international participation, mixed or hybrid criminal jurisdiction, or following the more frequent characterization, internationalized courts. It's the case of a court for the administration of Kosovo, the Special Court for Sierra Leone, the Extraordinary Chamber of the Courts in Cambodia, the War Crimes Chamber of the Court of Bosnia and Herzegovina, the Special Tribunal for Lebanon, the Kosovo Specialist Chamber. The last one is still active, actually. So there's been quite a number of courts. And even now, the proposal of a new special tribunal for the crimes committed in Ukraine is on the table, though it's still uncertain whether it will be implemented. But the fact that the International Criminal Court is not effective may lead to another special tribunal on this occasion. I made this initial listing of this tribunal because the attention that has been given to these international jurisdictions, including by the media, has led to a decrease of attention to the role of domestic courts in ensuring the application of international criminal law, or at least to a perception that international justice, criminal justice, is mainly a matter for international courts, due also to the approach to international criminal law that was taken since the beginning in 1945, when the Nuremberg Tribunal was established, and in which the decision was to conflate, in a way, jurisdiction as substantive applicable law in addressing these issues. There was not separated clearly what is substantive law and what is jurisdiction. There are two fields that are not the same, of course. And here are some questions that maybe deserve to be raised as far as the respective role of international and domestic courts is concerned on this matter. First, is the internationalization of criminal justice brought about with the proliferation of international jurisdictions aimed at ensuring a uniform application of international law that may allegedly be difficult to achieve through the jurisprudence of domestic courts? This is a question difficult to address because the main criticism that was made to international courts was to fragment international law. Too many courts and fragmentation of the law, especially because you will see that these courts had to work not on written criminal law, had to work on customary law. And the interpretation of customary law may diverge very easily, as all international lawyers know. But other question, how is this trend impacting of the role of domestic court, which are also mandated to apply international criminal law? Is there a concurrent jurisdiction between international and domestic courts, or are they operating in different fields? Third, if there is jurisdiction, concurrent jurisdiction, do national courts play a secondary role subject to the guidance and control by international courts, as if there existed a vertical relationship between the international jurisdiction and the domestic jurisdiction? An answer to this question is not black and white, as frequently in law. And indeed, if we look back at the debate on the importance of domestic courts for the effective implementation of international law, that debate has accompanied the promotion of international criminal justice since its beginning, since its inception. During World War II, when the Allied powers met in Moscow in 1942, so before the end of the war, but considering the war would finish, to consider whether to create an international criminal jurisdiction to prosecute the members of the Nazi party responsible for war crimes, crimes against humanity, they mainly discussed the two options. I leave out the third option because there are really three the options. But the third option was not a very legal option, was to get the criminals and kill them. That was the easiest way of resolving the problem, of course. But I don't discuss this type of solution, and indeed was just flagged, was not taken up seriously. The two options they had was either to create an international tribunal or to bring the accused before the courts of the states where the violation had been committed after the liberations of these countries. So to go to domestic courts or have an international court. The discussion led to trace a distinction in the London Agreement later in 1945 between crimes that they called without a specific geographic location. That was the definition, perpetrated by the leaders of the Nazi government and party, and the other crimes imputable to minor official or private actors. The first ones, without any geographic location, consider, in fact, they had a geographic location, but were regarded as having no geographic location because regarded as affecting the whole humankind and not a specific state, not a specific location. They decided they were to be tried by an international tribunal. The second ones that had a geographic location had to be tried by domestic courts, by national courts. Initially, including the military commissions of the Allied occupation forces in their respective territorial zone in Germany. And indeed, the accused persons brought before these commissions largely outnumbered the leaders that were tried by the Nuremberg military tribunal. The same occurred with the Tokyo Tribunal, where the occupation forces military commission operating in the Pacific countries, like in the Philippines, in other countries of the Pacific, tried more Japanese accused than the International Tribunal established in Tokyo. So the same logic was adopted for the other tribunal. It is noteworthy that there was no formal relationship, let alone a vertical relationship, between the international Nuremberg and Tokyo prosecutions and the trials led by the local military commissions. They did not have concurrent jurisdiction and complied with different legal regime and statutes. The International Tribunal applied the statute annexed to the London Agreement, and many other courts applied the decision of the Supreme Commander for the Allied Four Powers on one side, and the Control Law number 10 and domestic law on the others. There was a different law, so they applied completely different law. They had different appeals. In the sense, the International Tribunal didn't have a proper appeal. There was a possibility of referring to the commander, to Allied commander, for asking for pardon or reducing of the sentence, while the military commissions had a proper appeal. In particular, the American, they were more active, had an appeal to the Supreme Court of the United States, because being an American tribunal, it was unavoidable to have from the national tribunal a possible appeal before it. And in fact, there was one specific case, trial that occurred in Manila, in the Philippines, that was appealed to the Supreme Court that confirmed the decision, but with two dissents, very strong dissents, that then changed completely the law and the jurisprudence on the commander responsibility. This approach of having two separate systems formally did not change later. And the further step later were the Geneva Conventions of 1949 and the Protocol 1 of 1977. Because the Geneva Conventions introduced a regime of grave breaches of international humanitarian law, so war crimes, without mentioning even the possibility of prosecuting the authors of these breaches before an international court. They excluded entirely the idea of an international court. They stressed the role of domestic courts in the prosecution of war crimes by setting forth the undertaking of the states parties to the conventions, and I quote, to enact any legislation necessary to provide effective penal sanctions for persons committing or ordering to be committed any of the grave breaches defined in the convention. There is no mention on international jurisdiction at all, so this is just domestic courts that have to deal with international criminal law. And the obligation, they put the obligation of each state party to search for persons alleged to be responsible for the grave breaches and to bring them, regardless of the nationality, before its own courts, or to hand such person for trial over to another contracting party, provided that the other contracting party had made a prima facie case of the situation. So, while contributing to the definition of war crimes and stressing the importance of their prosecution by state courts, the Geneva Conventions did not address the question of how the relationships between a possible but not existing at the time concurring international and domestic jurisdiction should be regulated, because there was only domestic jurisdiction. They left the question open, of course, for proposals by the United Nations International Law Commission, which had been mandated in those times, in 1949, by the General Assembly of the United Nations to elaborate a draft code of offenses. against peace or security of mankind, and a statute of the international criminal jurisdiction to adjudicate such crimes. So the idea of having two systems, one international, one was still present in the United Nations, but was not taken up really. The International Law Commission couldn't proceed in this work because it encountered terrible difficulties, made a draft. The draft was not accepted by the General Assembly, came back to the International Legal Commission, and went back again. There was an up and down of this document. At the end, it was blocked because there was not agreement on the crime of aggression. The definition of aggression during the Cold War was extremely difficult, and there was a declaration in the 70s in the General Assembly, but that was remained dormant, actually, until the statute of the International Criminal Court. So it was not effective, this definition. And as aggression was also part of the problem had been a subject for jurisdiction in Nuremberg and in Tokyo, clearly this was a problem that had to be resolved, and the two blocks during the Cold War could not deal with that. So nothing was done for many years. And until the 90s, when the two tribunals ad hoc for Yugoslavia and Rwanda were decided by the Security Council, nothing happened on the idea of the international jurisdiction. What the domestic jurisdiction did from time to time was to decide some cases, but not on the basis of the Geneva Conventions, in reality, more generally on the basis of general international law. The Eichmann case decided by the Court of Israel, for instance, was one of these cases. The Barbie case in France, but were randomly taken up. There was no real problem with the international criminal law. Now, when the two ad hoc tribunals were established in the 90s, what did the Security Council do on this matter? Because the International Law Commission had not finished its work. And so there was an idea of what they would do on this matter. The Legal Council of the United Nations had to propose a statute of the ICTY in 2 months. Didn't know exactly what to do. So he took up the statute of Nuremberg and copied it, basically. But did something on the question of the relationship with domestic courts. And put an article in the statute saying that the International Tribunal and national courts shall have concurrent jurisdiction on the application of the statute of the tribunal. So it was not just for the tribunal. But established also that the International Tribunal would have primacy over international courts. So decided the issue of vertically putting the international court first and the domestic courts on the second level. And even said that at any state of the procedure, the International Tribunal could formally request national courts to defer to the competence of the International Tribunal, even if the trial was already on, could be stopped and had to be sent to the Hague, to the other tribunal. And indeed, the first trial before the ICTY concerning the accuser, the famous Mr. Tadic, whose case was pending before a German court for crimes, but the German court was requested to defer to the primacy of the competence of the International Tribunal, and the person, the accused, was sent to The Hague to be tried there. The primacy of the international jurisdiction was, of course, in a way, reaffirmed by the statute of the ICTY under the rule well known in criminal law of ne bis in idem. No, there can't be double prosecution on the same facts. And an article of the statute says that no person shall be tried before a national court for acts constituting serious violation of international humanitarian law under the statute, for which that person has already been tried by the International Tribunal. By contrast, it was attenuated this when the national concurrent jurisdiction of domestic courts had already been fully exercised. In this case, the statute provided that the judgment of a national court would in principle prevent the exercise of international jurisdiction, so would have priority. Stating that a person who had been tried by a national court for acts constituting violation of the statute might be subsequently tried by the National Tribunal only if the act for which that person was tried was characterized as an ordinary crime, not as an international crime. Or the national court proceedings were not impartial or independent, were designed to shield the accused from international criminal responsibility, or the case was not diligently prosecuted. So the ICTY statute recognized the priority of the domestic jurisdiction, but introduced a vertical relationship with international jurisdiction by allowing the International Tribunal to disregard the national judgment and hold a new trial if the act was tried as an ordinary crime or the national court proceedings did not respect basic principle of fair trial. The first situation reflects a distinction to be made between international and domestic crimes, even if that distinction is frequently based only on a contextual element. That is the connection with the conflict, with an armed conflict for the war crimes, and the existence of a widespread or systematic attack against the civilian population for crimes against humanity, not on the conduct of the perpetrator. An assassination as a murder, as a war crime, is a murder committed in war. The same act remains a murder if it's an ordinary crime. But the distinction was only based on that, not on the conduct, essentially, on the context in which the crime was committed. And the question of was easy to resolve maybe if the case has not diligently prosecuted or was not prosecuted according to fair trial principles, because in that case, one can assume that the sham trial is not a trial, simply. So there is no precedent, actually. So you can retry again simply because the first trial is null and void. So there is no reason to prevent further crimes. What happened with the Rome statutes, with the ICC? Because the problem had to be taken also there. First, the Rome Statute affirms a concurrent jurisdiction of international and domestic jurisdiction. But adopts a different approach with the relation to the priority between this jurisdiction as compared with the ad hoc tribunal for Rwanda and Yugoslavia, because deals with this problem in terms of admissibility of the case before the International Court, and recognize the principle of the complementarity of the international jurisdiction with respect to the national one, and therefore states that in principle the International Court shall declare a case inadmissible if the jurisdiction is exercised by a domestic court, and thus give priority to the domestic jurisdiction, not to the International Court. And including in a case in which a domestic court has decided not to prosecute. So the mere fact that the person is brought before a domestic court is sufficient to exclude the jurisdiction of the International Court. Of course, there are some conditions given that priority, otherwise the work of the court would be useless, maybe, which require some measures that echo the present approach of the ad hoc tribunals in a way. So the court shall determine that a case being investigated or prosecuted is admissible if the state which has jurisdiction over it is unwilling or unable genuinely to carry out the investigation or prosecution. And in that case, can take the case. It's a question of admissibility. If the state where the crime occurred is willing to proceed or is able to proceed, has a capacity to proceed, the court doesn't have simply jurisdiction. Of course, if there are unjustified delays in the proceedings, in the domestic proceeding, the court can intervene. Or if the purpose of the national trial is to shield the accused, to protect the accused instead of trying fairly him, there is a possibility to intervene. But what is dropped is the question of the ordinary crime. So the fact that the crime is prosecuted at domestic level as an ordinary crime prevents the jurisdiction of the court. Unless the prosecutor proves that the trial with as an ordinary crime was made to protect the individual, but that becomes a problem of evidence that is difficult to reach. So when they deal with the nebis in idem principle, the statute of the International Criminal Court gives priority to the domestic judgment against the international jurisdiction. There is an article in the statute, Article 20, which does not assign any weight to the distinction between ordinary and international crime. So, in fact, is given weight to the conduct and not to the context in which the crime occurs. And the fact that somebody is, a person is tried for the conduct means that this may be a reading is that is more in line with the principle of nebis in idem, but of course is not in line with what the two ad hoc tribunals said, because they said that the question of the context is a different element and therefore makes the two crimes different ones that can be prosecuted twice in a way. So if we look now at the current state of affairs as to the relationship between international and national criminal jurisdiction, one may come to the conclusion that notwithstanding the proliferation of international courts and tribunals, domestic jurisdiction has a primary role to play in ensuring the application of international criminal law and in the achievement of international justice. The formal recognition in the Rome Statute of the principle of complementarity is just the last acknowledgement of this primary role that was accepted even earlier in practice, for at least for two reasons. First, international criminal justice cannot be achieved by simply shifting criminal jurisdiction over international crimes from the domestic to the international level. That is simply impossible. The dimension of the commission, the number of commission of these crimes when there are turmoils and problems in a state or in a war in more states is such that it's impossible to assign jurisdiction over them only to international courts. It would be impossible practically to do that. So some weight has to be given to the jurisdiction of domestic courts. Moreover, it has to be regarded that even leaving to international jurisdiction only the leaders, high level, does not resolve the problem, because in practice, it has been assessed that the numerous crimes that would remain out, not committed by the leaders, but the main leaders, they may look less important, but in fact, they frequently affect the civilian population in their daily life much more than the crimes committed by leaders. Because in this situation, take the genocide in Rwanda, was committed by the population. Neighbors killing neighbors and so on. And at the end, when people have to go back to their villages, you have to bring about a common life in that community. And if the lower level have not been prosecuted, you can't do that, because they remain around without being prosecuted. So national jurisdiction become extremely important in that fact. And then there is another issue. An international criminal jurisdiction typically sits and conducts proceedings far from the place of the commission of the crime. And notwithstanding the existence of currently of means of communication that allow to follow what happens in abroad, the impact on the population is limited as compared with a direct participation in the judicial activity that may be carried out by the domestic court. So the direct involvement of the people that were affected by the events during which the crimes were committed is critical for bringing about closure to the victims and started to a more solid basis in new community life. For these reasons, even if the international tribunals we were assigned a priority vis-a-vis the domestic courts, the ICTY, the ICTR, they themselves had to come to the conclusion at a certain point of their lifetime that they had to give priority to the domestic courts, although they had priority, but they had too much work that one body, one court cannot do. So at the end, even we, from a certain moment, we sent back cases to the local jurisdiction. Even accused that were already arrested and being in The Hague were sent back to the domestic jurisdiction. And there was the pressure, of course, of the Security Council to finish the work of this ad hoc tribunal. But at the end, what we had was imagined by the Security Council to be a completing strategy of the tribunal in order to finish its work, was transformed by the tribunal in a continuation strategy, in a continuation before the domestic courts. And much of the activity in the last years of these tribunals was done through helping and giving some guidance or even practical help to domestic courts in order to finish the work, more than in trying cases before. So in conclusion, the role of domestic courts in contributing to international justice is essential and has become the more and more important in the light of the developments, especially after the entry into force of the Rome Statute of the ICC, which defines the jurisdiction as complementary to the domestic jurisdiction, and recalls that this is the duty of every state to exercise its criminal jurisdiction over those responsible for international crimes. It's the statute of the International Court that says that. There is a rule in the preamble part, which, by the way, does not relate only to the international crimes over which the ICC has jurisdiction, but extends to those which do not meet this requirement. And this, incidentally at least, I have to remember one thing, which is important in international law, however. The Rome Statute of the International Criminal Court is true. It establishes a permanent court, a court that should be remain the court, the criminal court, international criminal court, but has a problem. This statute is a restrictive statute, does not codify international criminal law, as it can be assessed on the basis of customary law. And here we come to one of the main issues in international law, the question of the sources. Because when you have customary law proceeds its way. When you have a codification of customary law, frequently is not a full codification of the law, because there is an international conference, the delegation of the states have different views, and at the end, a sort of common standard is accepted, which reduces the obligations of the states as they are exist under customary law. And this has been done very much in the Rome Statute. If one compares the case law of the tribunals that had to work on customary law and the Rome Statute is clearly as a narrower dimension. The scope of the crimes is war crimes has reduced, notwithstanding the statute that says that the jurisdiction of the court refers to the most serious crimes concerned to the international community as a whole. In reality, it for the crimes against humanity, it reduces the size of the provisions on the crimes against humanity by saying that these crimes are those committed through an attack against civilian population, but then it adds, pursuant to or in furtherance of a state or organizational policy. This precision is not in customary international law. It has never been applied by the tribunal, by the ad hoc tribunal. Then it restricts the war crimes, saying that those crimes, over these crimes, there is jurisdiction of the court when they are committed as part of a plan or policy or as part of a large-scale commission of such crimes. This restriction is not in customary international law. So at the end, the court restricts, usually, has this jurisdiction restricted by the, and in a way, there is not fully concurring jurisdiction. If international law, and so the jurisdiction is limited in its scope, its material scope, substantive scope, what is not given to the court remains inevitably with domestic courts. There is no other way to resolve the problem. But at the end, the place of domestic courts becomes still very important, and we are back in a way for many crimes to the situation of the Geneva Conventions, in which there was only domestic jurisdiction. I'm not to say that, I don't want to say that the court is useless, of course. There are domestic courts, but it's impossible to have a full implementation of international law on the basis of the court. That's more general for international courts, of course. But if you take, for instance, the ICJ, it has general jurisdiction. It's limited procedurally because the parties must agree to go to the court. But as when they go, unless they specify the limits within which they go to the court is free to decide on the dispute, to apply entirely international law. Here, clearly, we have a court which is not fully entire. And then you have to add one final element, which is that not only the substantive jurisdiction is limited of the International Criminal Court, but the court should be universal. And it is not. It is not because the statute has been ratified by 125 states, which is, if one look at the numbers, is 2/3, roughly, of the international community of states, because the members of the United Nations are 193, so more or less 2/3, but in fact it's much less. It's much less because if you take it that criminal prosecution is a means of protection of human rights, through the prosecution, you try to prevent the commission of human rights. And the crimes are a violation of human rights internationally. So at the end, you have to look at the population, which is protected. And if you look at the population, these 2/3 become roughly less than 1/3 of the world population. So this gives, again, responsibility to domestic courts. And domestic courts should go back to have and apply this provision of the Geneva Conventions, in which it is said that they should exercise universal jurisdiction irrespective of the fact that the crime is committed in the country or against citizens or by citizens of a country. A state where a person is should have jurisdiction in any case. So, but if this principle is applied, we should better arrive to a solution. the court may still exist and do some work. But if you take into account that in more than 20 years of activity, he has decided 10 or 12 cases, it's clearly a very limited impact on a problem which is a problem which is more wide than one would appear. And in the current world, I mean, look at the armed conflict that exists in the world now. It's the number of cases is terribly huge and cannot be brought before an international court at all. I stop here. Thank you for your attention.
Thank you. Thank you very much, Professor. It's really, as I told you, an honor for us to have this really profound lecture about the subject you proposed to us. And I can say we achieved what we really wanted for this moment, which was a magnificent lecture about international law while we're having in Natal the Brazilian Congress of International Law. So we thank you from the bottom of the heart for a generous, for you to generously share your ideas with us. Thank you very much. Uma salva de palmas mais uma vez, minha gente. If you don't mind, we would like to take a picture with the judges here to mark this moment with you. Is it okay? Thank you. Então, eu chamaria aqui os juízes para baterem. Eu sei que a turma vai querer bater uma foto também, né? Mas eu chamaria os juízes aqui para a gente bater uma foto. Ministro, por favor, venha também bater essa foto conosco, por gentileza. Bora, turma. Flávia também, por favor, por favor. Eu queria, Sidney, que você viesse também, venha bater a foto conosco. Então, mas sim, o professor de Direito Internacional tem que estar com a gente. Sendo assim, nós damos por encerrado essa noite. Sendo assim, nós damos por encerrado essa noite, lembrando que quinta-feira teremos uma segunda edição, o tema Direito Probatório. Ah, é verdade, desculpa. Não, espera aí, então que você vai fazer o convite. Eu vou fazer um convite, o doutor Eduardo vai fazer outro. Quinta-feira nós temos uma quinta jurídica sobre direito probatório com a presença do desembargador Fernando Braga, que é o presidente do TRF da Quinta Região, e o professor Geraldo Prado, da UFRJ. Então, vocês ficam convidados e surgirá ali um outro convite.
Na quarta-feira, às 17 horas, a gente vai ter o Cine Quinta Jurídica, enfim, é a primeira edição, uma novidade que a gente lançou nesses 20 anos, que é uma coisa muito bacana de juntar, assim, arte, cinema com direito, né? Enfim, teremos pipoca grátis, tão atrativo também para quem quiser vir. E o filme escolhido é um filme fantástico, não sei se vocês já viram, um filme recente chamado Anatomia de uma Queda, que tem, assim, para os estudantes e até para os mais, né, tarimbados, é um filme muito interessante que mostra o papel dos atores do processo penal, sobre a argumentação, preparação, né, para um júri ou para uma audiência, enfim. E depois do cinema a gente vai fazer um breve debate sobre, enfim, as posições das partes, os argumentos, e vamos até fazer Você Decide, né, para quem lembra do Você Decide durante o cinema, para vocês votarem sobre o resultado do julgamento e a gente comparar aqui com argumentos e perspectivas do processo penal. Okay? Obrigado a todos.
Bom, minha gente, muito obrigado. Fiquem com Deus.